Okay, so now let us talk about confessions in admin proceedings. Remember, there is a rule, no? That as a general rule, the rights under Article 3 can be invoked as against the state. So the same is true when it comes to custodial interrogation. You cannot claim that your confession is illegal when you confess before a private person. Okay? Why? Because he has no power to take you into custody. Okay? So let us look at some cases involving confessions in admin proceedings. Okay? In People versus Judge Aison, this involves an employee of the Philippine Airlines who was subject to an administrative investigation, no? And because he knew he was guilty when he gave his statement, he admitted to the crime. Okay? He in fact wrote a letter to the administration offering to pay off the damage. Okay? So he admitted to the crime during the administrative investigation, and then he also offered to pay the damage in a letter. Okay? This admission and the subsequent letter were later used against him in a criminal case. And so he objected to the admissibility of this evidence, claiming it was taken during custodial interrogation. But the Supreme Court said no. Okay? Those were not taken during custodial investigation because, first, PAL is not the state. He could not be taken into custody. Second, he voluntarily confessed to the crime. Okay? So there was no compulsion. He was not in custody. Therefore, it is not a result of custodial interrogation. Similarly, in the case of Oka versus Sumilang, the Office of the Court Administrator was investigating a court staff in relation to some missing fees that were supposedly paid to the court but were never transmitted properly. Okay? So, there was an investigation. He made a statement. He was asked to sign that statement where he admitted committing the offense, and that was later used in a criminal case against him. He objected to the admissibility, claiming it was a result of custodial interrogation, but the Supreme Court said no. Okay? Why? Because the court administrator could not take him into custody, so he was not in custody. Second, these are not law enforcement agents, no, that represent the state that can compel a confession. Okay? So it was an administrative investigation. So any statements made there cannot be said to be compelled confessions. So sabi ng Supreme Court, it is admissible in evidence. In People versus Uy, here, it was the National Power Corporation that conducted an investigation. Again, this is an administrative investigation. Again, he gave a statement. Okay? Executed a sworn statement admitting to committing elements of the crime. This was later used as evidence in a criminal case. He objected. And just like in the other cases, sabi ng Supreme Court, a statement given during an administrative investigation before a corporation is not a confession in a custodial interrogation. No? First, he was not in custody. Second, he could not have been compelled. Therefore, it is not a result of a custodial interrogation and hence admissible against the one who confessed. In People versus Malingan, here, there was a housemaid, no, na inapi ng kanyang amo. Supposedly, she was not being paid. And then when she said, I want to go home na to my province because I'm not being paid naman here. And the woman, her amo, instead of, being kind and nice to her, said, di ba mukha ka naman bruha, so ba't di ka kumuha ng walis, sakyan mo pa uwi? I suppose that was the last straw. So when the family slept, she burned the house. And then, as she was leaving the house, someone saw her. So she was arrested and detained in the barangay. So while she was in detention, a neighbor visited her. Kaibigan niya siguro, no? Visited her. Tinanong siya, ba't mo naman nagawa? Sabi niya, kasi napakawalang hiya nila sa akin. So, hindi ko na natiis. Makaganti man lang ako. So, she admitted, she confessed to the crime. Okay? Is that admissible? Supreme Court said, The interrogation before the barangay was custodial interrogation. Therefore, because it was uncounseled, it is inadmissible. However, the confession made to her neighbor is admissible. Why? It was not a result of custodial interrogation. The neighbor was not part of the barangay nor of the police. No? So, she voluntarily confessed to a friend. And then that voluntary admission is admissible against her. Okay? Now, the Constitution requires that during custodial interrogation, there must be an independent and competent counsel. The reason for this is to make sure that if the accused will decide to confess, it is a genuine confession, not a compelled one. So, the requirement is an independent and competent counsel. So please, no, if you are asked to be there, perform your job. No? Because like in People versus Hayabo, during interrogation, the accused asked for a lawyer, so a POW lawyer arrived. Stayed with him throughout, but never uttered a single word. He ended up confessing to the crime. Okay? But during the trial, he questioned the confession. And the Supreme Court, after reviewing the record, said the perfunctory manner in informing the accused of his rights was not enough. Moreover, the silence of counsel showed that he was not vigilant nor competent in protecting the rights of the accused. Therefore, although there was a lawyer physically present, no, it was as if there was no lawyer. And hence, the confession was considered an uncounseled confession and therefore in violation of Section 12, therefore inadmissible against the one who confessed. In People versus Labtan, the accused was interviewed at 8 o'clock, interviewed in quotes, no? Which means he was already being interrogated while in custody. Lawyer arrived at 10 o'clock. This is the lawyer, yun yung katabi ng police station. Okay? Mapapansin nyo naman, in near every police precinct, there's a law office there. Okay? And then, the said counsel who supposedly assisted during interrogation was also the same counsel who notarized the confession. Is that admissible confession? The answer is no. Why? Because when he notarized the confession, notarization of a confession basically says that this document was executed properly by the person who appeared before me that I confirm to be that same person. That's what a notary does. He attests to that. Now, in this case, the counsel who notarized is the same person who assisted the accused. So he is attesting to the regularity of the performance of his own job. So merong conflict of interest doon. He cannot attest to the regularity of his own performance, di ba? Sabi ng Supreme Court, this is a conflict situation that is not acceptable. So either it was not notarized or, hindi pwede. Kasi siya nag-notarize, siya rin nag-assist. Hindi pwede. So the confession was held to be inadmissible against a person because the counsel was not an independent counsel. He was in a conflict situation. In People versus Bagnate, here the lawyer was called by the police. When he arrived, he asked the police to leave. Please leave the room. I need to consult with my client. Okay? He advised his client, but thereafter, client decided to confess. He assisted the client. After confessing, signed the confession, brought him before a judge so that before the judge can confirm or attest to the regularity of the confession. Later, the accused claimed that he was compelled, that it was an illegal confession because the lawyer did not advise him of the penalty of the crime to which he confessed to. So sabi niya, hindi ako tinulungan ng isang independent and competent counsel because he never told me the penalty. Was he correct? Supreme Court said no. The duty of the counsel, is to advise him of his right to remain silent, and any statement may be used against him. That is the duty of the counsel. Okay? It does not require him to advise the accused of what is the possible penalty should he decide to confess. Okay? So sabi ng Supreme Court, the confession is still admissible. In People versus Gallardo, okay, accused was assisted by a lawyer given by the police. After after they were advised by counsel, they decided to confess. And so the counsel assisted them in writing their confession, signed it, and then he brought them before a judge where they took an oath, attested to the validity of the confession. Later, they wanted the judge to consider the confession inadmissible, claiming that the lawyer was not a lawyer of their choice. Diba? Constitution says preferably of their own choice. So sabi niya, hindi naman namin abogado yan eh. But he assisted you. But hindi namin siya choice. We should be our choice. And the Supreme Court said, when the police gives you a lawyer and you accept his services, okay, then that makes him your lawyer. Lawyer of choice nyo na yun. Okay? Kasi you can reject him naman eh, but you accepted him. And so that makes him your lawyer. In People versus Januario, okay, here he was arrested in Bicol by the NBI and he was interrogated there where he supposedly confessed. Dinala siya sa Manila, again he was interrogated and a sworn statement was taken. But the NBI realized, teka, walang assistance ng counsel. So what did they do? They got an applicant for a position in NBI. During this time class, ang NBI can only be an NBI agent if you're a lawyer or an accountant. So an applicant who was a lawyer, they called him, halika, assist this person to execute his confession. So inassist. Okay? Is that an independent and competent counsel? Obviously not. Diba? Obviously not. One who is applying for a job at NBI, when asked by the NBI to assist an accused in his confession, cannot be considered an independent counsel. Of course, he will try to please hopefully his future employers, diba? So hindi yan competent or independent counsel. And finally, in People versus Morial, okay, accused were arrested. While in custody, a lawyer was brought to the accused. He agreed to be, the accused supposedly agreed to be represented by counsel. Okay? But in the middle of the interrogation, the lawyer had to leave. The interrogation continued. They decided to confess. Okay? Is that admissible? No. Okay? Like I said earlier, counsel must be there throughout, from the beginning to the very end. So if you are the policeman, okay, conducting the interrogation, if counsel has to leave, stop. Do not continue. Because if you continue, that will be a tainted interrogation. And whatever you get out of it will become inadmissible. Okay? Which is what happened in this case. Okay? So, I will have one more recording for our last topic under Section 12. Unfortunately, the time given to me by YouTube cannot accommodate that last topic, so that will be reserved for another recording. Thank you.